5 seconds to go. Start. We should have thought that the fact that a criminal case is pending against the person who is sought to be proceeded against by way of preventive detention is a very material circumstance which ought to be placed before the district magistrate. Stop. The circumstance might quite possible have an impact on his decision whether or not to make an order of detention. Stop. It is not altogether unlikely that the district magistrate may, in a given case, take the view that since a criminal case is pending against the person sought to be detained, no order of detention should be made for the present, but the criminal case should be allowed to run its full course and only if it fails to result in conviction, then preventive detention should be resorted to. Stop. It would be most unfair to the person sought to be detained not to disclose the pendency of a criminal case against him to the district magistrate. Stop. Para. From the above decisions, it emerges that the requisite subjective satisfaction, the formation of which is a condition precedent to passing of a detention order, will get vitiated if material or vital facts which would have bearing on the issue and weighed the satisfaction of the detaining authority one way or the other and influence his mind are either withheld or suppressed by the sponsoring authority or ignored and not considered by the detaining authority before issuing the detention order. Stop. Para. It is clear to our mind that in the case on hand, at the time when the detaining authority passed the detention order, this vital fact, namely, that the appellant detainee had been released on bail by the special court, Tripura, despite the rigors of section 37 of the NDPS Act, 1985, had not been brought to the notice, and on the other hand, this fact was withheld and the detaining authority was given to understand that the trial of those criminal cases was pending. Stop. Para. The preventive detention is a serious invasion of personal liberty and the normal methods open to a person charged with commission of any offense to disprove the charge or to prove his innocence at the trial are not available to the person preventively detained and therefore in prevention detention jurisprudence whatever little safeguards the constitution and the enactments authorizing such detention provide assume utmost importance and must be strictly adhered to. Stop. Para. In view of the aforesaid discussion, this appeal succeeds and is hereby allowed. Stop. The judgment and order passed by the High Court of Tripura is set aside. Stop. The order of preventive detention passed by the state of Tripura dated 12th November 2021 is hereby quashed and set aside. Stop. The appellant herein is ordered to be released forthwith from custody if not required in any other case. Stop. Para. Pending application, if any, also stands disposed of. Stop.